Jai Hindi, belonging to Uttar Pradesh state. Hindi being my mother tongue. Our court language is also Hindi. We are bound to pass our verdicts in Hindi as per the regulations issued by Honorable High Court. I will take this opportunity keep my suggestions, my presentation mainly in Hindi. And apart from keeping in view the pan India culture and the gathering over here, I will use Tiglet. Thanks. Our respected previous speaker, Honorable Additional District Judge from Jalgaon, Maharashtra, he has spoken a lot. He has also discussed few lacuna and latches that are faced by judicial officers while determining the basic concept that has been given to us, compensation. Compensation, as we all know, that is determined at the end of trial, rather passing of sentence. And at that moment, we, deciding officers, don't have any material before us regarding the status of victim, regarding status of accused offender. So, there should be bounden duty of IU to inculcate those material evidence in his investigation. So I really appreciate suggestions given by our previous presenter. Any learned, intelligent, intellect audience को if I define what is victim, थोड़ा मुझे सोचना पड़ता है. But as a part and parcel of this project, victim क्योंकि actual सफरा है, इंसिडेंट का, किसी घटना का, किसी ऑफेंस का. Apart from victim, एक होता है directly conflict of this, क्योंकि ऑफेंस हुआ, directly concerned person, maybe injured person, maybe as we see in past cases, maybe a child, male, female, who are directly affected, adversely affected with the offense. Victim may be the family members of the main victim. Rather, if we go remotely, some of relatives as well as the society at large also very much can be considered to be one of the victims of a crime. Now going ahead, this is all, you all are very well acquainted with this part also. The part or in what manner the victim suffers. In case of injury case, certainly victim receives injury. In case of dacoity, और जो सेक्सुअल ऑफेंसेस के मैटर्स हैं उसमें फिजिकल डैमेज as well as mental trauma that is more severe and grave. So that is also a kind of suffering. Sometimes offender is so capable deterrent इसके सामने इसके खिलाफ गवाही देना तो उसके सामने किसी प्रकार से खड़ा होना There is even police station it is difficult. Remote areas में ज़्यादातर आपको देखने को मिलेगा and mainly in the atrocities case or where the vulnerable society resides. वहाँ के incidents इस तरीके के होंगे. You will feel there is fear of the family also, not only the victim. So this is also a kind of suffering even for victim itself, family members, as well as that particular society. Now, एक बार को साहस करके हमारा विक्टिम थाने पहुंचता, अब उसको अगला डर ये है कि थाने में हाउ पुलिस विल that is also a kind of suffering. फिर आता है कि डॉक्टर मेरा किस तरीके से एग्जामिनेशन करेगा, स्पेकुलेशंस दिमाग में आते हैं, मेनली फीमेल विक्टिम क्या उसके साथ होगा क्या नहीं होगा. This is also a kind of suffering. किस तरीके से इतनी मास गैदरिंग में और कोर्ट अगर प्रिकॉशन भी लेती है तो भी एटलीस्ट पीओ डिफेंस.
सर मैं निवेदन करना चाहूँगा सर, जस्ट सॉरी टू इंटरप्ट यू सर, हमारा जो पॉइंट है उसको हमको एक्सप्लेन करने की आवश्यकता है कि हमारी मंशा क्या, बस उतना शॉर्ट में समझा सर, क्योंकि हर स्पीकर के पास सिर्फ 6 मिनट का टाइम है. हम 6 मिनट से 7 मिनट कर सकते हैं, 8 मिनट कर सकते हैं, उससे ज़्यादा.
What are the provisions regarding compensation? You all know. Very good. Keeping in view the time constraint, I will suggest the judicial approach to be adopted. That is paramount for this particular discussion. Is number one, the opportunity of hearing should be given to the victim at each and every stage of the proceedings. That is right. Right from bail, even prior to the trial, stage of bail, taking cognizance, framing of charge, passing of sentence, as well as in appeal also. She should be given proper respect as well as the opportunity of being heard through adequate counsel, legal assistance. Now, another part that, another role that the presiding officer has to play is to act like a facilitator. Means whatever government schemes are there, whatever facilities are provided by DLSA, etc., court should even see whether all these facilities, the helps, they are being provided to the victim or not. If not, court should direct and pass orders accordingly. Later on, there are two forms. Suppose कोर्ट का ट्रायल पूरा हो गया, आप सेंटेंसिंग पर कोर्ट पहुंच गए और कोर्ट ने उसको कन्विक्शन भी किया. There may be two situations. अगर offender is convicted, then the victim from the offender, keeping in view the status of offender as well as the gravity of the offense and effect that will be on the victim. So restitution is given by the court from offender to the victim. Second is compensation. This is given from the government program schemes, government schemes. When compensation should be the court by passing the sentence also include this part that because the amount of restitution is not sufficient, not enough, therefore court requires that the victim should be compensated from the government schemes as provided, and for that reason court can write something in its order to DLSA to facilitate or compensate in the manner prescribed by DLSA authorities. Now, the circumstances that are to be taken into consideration is the gravity of victim's offense, the offender's surrounding and status, whether court want to impose the amount of fine or compensation, the offender is in the capacity to pay it or not. Similarly,
सर 1 मिनट और
एक मिनट है
हो चुका है वैसे, एक मिनट और।
So, I think from this platform, I will try to put my suggestions. First of all, particularly the women victims, they should be those courts who are dealing with those cases that should be decided by a women. This is my first suggestion. Secondly, while examining the witness, it should be the duty of PO to note down the examination in their own handwriting. This is my personal experience, so that you will find many times you need a lot of intervention while the defense counsel is cross-examining the witness. If we leave it on our reader or leave it on our steno, it will not fulfill the very purpose for framing of the system. Okay, then, lastly, concluding with my topic, the court should try to provide such harmonious atmosphere to the victim so that she may feel free to narrate her version, whatever she wants to narrate. This is our last speaker also said, the court should note down the demeanor of victim as well as accused. This is all on my side. Thank you all for listening.
सर मैं वहाँ पर 6
So first of all, since yesterday we are learning the definition of victim, so I will not repeat the same. Only I would like to add in that victim, we have defined that the person who has suffered or who has been caused harm, including his family members, relatives, or the persons who have been affected due to that harm. In addition to that, a person who has intervened when the incident was occurring, at that time when the person who has intervened is also victimized. He also has included in the definition of victim. Now the topic is judicial approach towards victim. In that regard, Maharashtra government, after direction given by Honorable High Court, has introduced Manodhairya scheme. Now we are on the topic victimization, victim's right, victim compensation. So from the term, from the word itself, we can understand what is the purpose and what is the object of this Manodhairya scheme. Manodhairya. So when we suffer from anything, we need, even if we feel ill health, at that time what we need is support, relief, courage. So Manodhairya is Manodhairya. Courage is needed to that particular person to come out of that trauma, to come out of that injury or any harm or loss. So Maharashtra government has introduced the scheme. So what are the features of this scheme? Before going to towards features, I would like to quote here. Manodhairya scheme offers compensation to the victim ranging from rupees 3 lakh to 10 lakh. So, what are the instances in which the victim gets this compensation? Now, under the scheme, who are the victims? Not only women, but children and also people belonging to the vulnerable section. The scheme provides financial help to the victims. It ensures medical help and free legal assistance for the victim. It covers expenses towards medical treatment, legal aid, counseling, rehabilitation. It helps victims to recover from trauma. So now the question arises, how victims come out from the trauma. So the responsibility is cast on DLSA. So DLSA, what they did, they arranged certain programs. Before that, the procedure I want to clarify here. Whenever FIR is lodged with police, the duty is cast to the police that the application along with that FIR is to be sent to the DLSA. And that victim is also forwarded to the DLSA office where the cognizance of that particular incident is being taken, and according to that, the remedy is provided to that victim. Now, for implementation of the scheme, the committee is formed, which include district collector as president, district women and child welfare officer as member secretary, and other members include superintendent of police, deputy commissioner of police, and district civil surgeon. Even if it is in the scheme included all these persons, but Honorable High Court has cast most of the responsibility on DLSA to look after, to take care of victim and to see whether the compensation which is granted under this scheme is being provided or not. Now, who can avail this benefit under this scheme? The offences are covered under this scheme under section 375, 326A, 326B of IPC and section 3456 of Protection of Children from Sexual Offences Act. Very sorry if there is spelling mistake or disturbance, because it may cause that inconvenience for reading also. Because in hurry that presentation has been prepared, therefore there may be spelling mistakes or some inconvenience.
Don't worry, we all are sailing in the same boat. Don't have to say that.
So I was on the point that which offences have been covered under this scheme, and for that purpose, as I earlier I have said that application along with FIR is to be sent to DLSA. Then the authority collect the documents such as identity proof, residential proof, copy of FIR, medical report if it is there, and those documents are being forwarded to the authority. Authority assesses all those documents and forward it, and it is mandatory under this scheme that after lodging, after registering the FIR, within 1 hour, the application along with copy of FIR is to be forwarded to DLSA. And within 7 days, the entire procedure is to be completed from the receiving of all these documents. That an assessment will be carried out in such a way that whether the particular victim is eligible for the benefit of the scheme. So you can apply for this. The victim herself can apply, or
Ma'am, 1 minute more.
One more minute.
One more.
or relatives. Uh, some are instances in which the compensation has been granted up to 3 lakhs in cases of acid attack because there was permanent disability and disfiguration. Just like in MSCP cases, 140 under 140 section, the compensation is was being awarded 25,000 and 50,000. So prima facie, 50,000 rupees was granted to the victim in acid attack. Now, the main important thing is rehabilitation of the victim. So that is our role. A child when fall down, we don't ask why you have fallen down. We say yes, okay, it will be covered. So that is role which is assigned to us as per my understanding. So what kind of rehabilitation is to be considered of victim? That is medical aid is being provided under the scheme. Legal aid is also provided.
Ma'am, time up.
And
Next.
only half minute.
Taking 10 minutes.
So, rehabilitation, on the point of rehabilitation, even vocational training are being provided to the victim so that they will be financially independent on their own. And even employment opportunities being given to them. So, all these are arranged by DLSA.
Group
So,
C.
this is the rehabilitation, and what is the role, as per my understanding, what is the role of judiciary when we are treating with the victim, that though we should feel them that you have not done anything, but what has been done, it will be cured because the show must go on. They have to live their life with dignity, liberty, and with fundamental rights. So this is the role of judiciary. Thank you.
हाँ? नहीं बैठिए.
No.
Namaskar. Since other officers have talked about what is impact compensation, who is victim, and the need for their rehabilitation, I will limit only to the victim right to participate in the trial and at what stage. So, with the introduction of section 2 of CIPC, the victim has been defined and some independent rights are given to the victim. So now it is not that the victim speaks through the mouth of prosecutor. Victim has independent right. For example, section 372 of Criminal Procedure Code speaks about the right of victim to prepare an appeal in case there is an acquittal or compensation awarded is less. However, there is no provision for preparing appeal given by the victim
in a case of inadequacy of sentence. So, in a case of acquittal and less compensation, victim can file an appeal before session court against the order of acquittal by the magistrate. But if there is an inadequate sentence, the victim will be required to go before the High Court. So, I think that the victim should have been given an opportunity to prepare an appeal before the session court, even in case of inadequacy of sentence. So, the case is initiated with the registration of FIR, and when the judge receives the copy of the FIR, it is for him to ascertain the nature of offense and the position of the victim, so as to at least form an opinion as to whether the victim, what sort of help the victim needs, and if a victim is entitled for medical help or provision of like shelter or something like that, and the investigating officer has to comply certain provision of the law, then it is for the judge to oversee as to whether the investigating officer has complied his duties, including providing the copy of paper. This paper has been divided into three parts. At the stage of bail, it has been already discussed. But since the victim has independent right to participate in the trial, while the deciding an application for bail in non-bailable cases, it is for the judge to issue notice along with the prosecutor to the victim, so that she should have an opportunity to appear before the court and put her grievance forth, so that she could resist the application. Even after filing of the charge sheet, the victim should have been given copy of FIR. There is no provision in the CRPC at present that the copy of final report should be given to the victim. We have proposed that there should be provision in the CRPC whereby final report, copy of final report should be given to the victim. It is with intention, for the reason that it is not only that the investigation terminates in the filing of charge sheet alone. It could be a negative report. So, just like a complainant can file protest petition against the B summary or something like that, the victim should have been given an opportunity to file protest petition against the negative. When the offense took place, it is for the judge to see that the trial should not be a second instance of humiliation. So, when the victim is before the court, either to face the trial, cross-examination, so the atmosphere in the court should be conducive. She should be treated with utmost sympathy. And during recording of evidence, judge shall see that the victim is not humiliated by way of aggressive cross-examination. It is for just to look after that the dignity of the victim is maintained. Again, when the trial is over, the name and the location of the victim should be maintained, should not be made public, so that the privacy can be maintained. There are some certain provisions like Prevention of Atrocities Act, where it mandates that when an application is moved by the prosecutor or by the victim, the judge shall not disclose the names of victim and witnesses when the judgment is going to be uploaded on the public portal, like we upload on the website. So, I have already stated that by amendment in section 372, victim has been given right of filing an appeal, but that right is not in respect of preparing an appeal when there is inadequate sentence. So, I am of that that right should have been given to the victim to prepare an appeal, because if rights are given in such a fashion that for one remedy appeal is before the session court, and for another remedy we have to appear before the High Court, it will not meet the ends of justice. Thank you.
Thank you so much, sir. And now I would like to request Dr. O.P. Tiwari sir to please come on the stage and distribute memento to all our speakers.
सांगितलेलं होतं ना सो
शिवानी मैम प्लीज वो भेजिएगा मेमेंटो हमारा. शिवानी मैम अगर आप सुन पा रहे हैं तो मेमेंटो भेजिए प्लीज.
पब्लिक स्पीकिंगचा खूप याच उभारून बोलू शकत फॉर्च्युनेटली मला आज 5 मिनिटं तरी का बोलता आलं या विषयी.